I will be the moderator for today's webcast. I welcome all of you. IFA-India Academy, as you know, is part of the IFA branch, International Fiscal Association India branch, and has been a leading platform for knowledge sharing and professional development in the areas of international tax and transfer pricing. Regular courses have been held by the Academy at its own center in Noida, as well as other places in NCR, and, with its aim to widen its reach, to reach out to more professionals, both in the industry as well as in the practice. We have taken the initiative to launch a broadcast uh, of through the online webcast series to discuss recent developments, key developments in the area of transfer pricing and international tax. Today is our inaugural webcast. We have two eminent experts who need no introduction, but I will nevertheless introduce them. In front of me is Mr. Mukesh Butani. Mukesh is the non-executive chairman of BMR Legal and the managing partner also there. He specializes in international tax, authored many books, and I remember you have been part of many of the task forces governing policies and tax administration. So welcome, Mukesh,
Thank you.
to the webcast. To my right is Ajay Vohra, senior advocate and formerly managing partner of Vash Associates. First of all, congratulations on your elevation. I think it's the first time I'm meeting you after that. Ajay is a well-known tax lawyer, needs no introduction, has argued many landmark tax cases, and has been on the forefront of cases involving transfer pricing and international tax. So we have a very high-powered panel today who will be providing very valuable insights on some of the topics we have for the next 1 hour. We have a fairly long list. September and October has been fairly event-packed as far as transfer pricing is concerned. And the one which tops the list as far as international tax and transfer pricing development goes is BEPS, base erosion and profit shifting. The final report, which came out in the first week of October, and has been endorsed by the finance ministers of G20 countries, seems to be fast approaching reality as we speak. And I think next month, the G20 summit, the heads of state are going to take it up. So, Mukesh, base erosion and profit shifting, very briefly, how has it come about? You know, what it is all about, if you can elaborate a little bit.
Well, I think there are two primary reasons why we have this project called BEPS. One, the only body that has been at the forefront on international tax policy matters has been OECD, which is what was labeled at one point in time as the Club of Rich Nations. I think after the 2008 crisis, it was becoming increasingly clear that there is a shift of economic power from the west to the east, China and India being the two large consuming countries. And the slowdown caused as a result of the 2008 crisis did not impact the emerging economies, or for that matter, the BRICS economies at that point in time. Of course, Russia and Brazil at this point in time are in deeper trouble, but I'm talking about 2008. And and this was more of a political agenda by the politicians, driven primarily with two objectives. One, to crack the whip on offshore accounts, and two, to be able to see that whilst this economic shift in consumption is taking place, how do you now put together or look beyond the Club of Rich Nations and embrace the emerging economies? And that's really the time the whole idea of the G20 was born. Though technically speaking, G20 was there even earlier, prior to 2008 as well.
Right.
But G20 driving the tax agenda for the world was really for these political reasons. So I think thereafter, I guess the only agency that was credible insofar as being mandated to look at the entire gamut of tax policy was formed. It had the political backing, so it was not like any other OECD committee looking after a permanent establishment attribution rule or a new transfer pricing rule. So I think it has received impetus largely because of the political backing. And then thereafter, from 2009, they started, framing the terms of reference, which are the topics they should cover. That's how those 15 action points got evolved, and that's how we saw that on 5th of October, early this month, the whole 15-point agenda was presented.
So this is why are people excited about it? Why are taxpayers and tax professionals both immensely excited about it?
Well, I don't know whether excitement is the right word. I would say anxiety is the right word.
Okay.
I think, firstly, this is going to bring about transformational changes in the international tax policies. And these transformational changes are going to also impact domestic tax policies as well. It's certainly for the G20 nations. And though it is labeled as a G20 project, there are about 20 other nations, 25 other nations that are observer status that are going to comply with the BEPS requirement. So you're talking about 45% of the world economy is controlling roughly 90% of the GDP. So it impacts 6 billion out of 7 billion people in this world. Why are people anxious, and why do I use the word anxiety rather than excitement? Transformational changes of this nature have never been seen earlier in international tax policy. Two, it is going to shift the basis for taxation from residence to source-based. And as you know, as we all tax professionals know, that there has always been this tussle between the residence and source-based of taxation. So that's one part of it. I think it signals largely an end to treaty abuse provisions. Substance will take over, precedence over form. I think it also marks a fundamental shift in the way people look at transfer pricing compliances. So the way we as Indian professionals have been looking at compliances is that this is Rule 10. We need to look at what Rule 10 says on transfer pricing documentation. Now with the country by country reporting, you need to give a wholesome look to this entire transfer pricing law. So there are other changes as well, but I would say that these are the 3-4 primary drivers. The one thing that I wanted to mention in the same breath is this exchange of information.
Right.
So though the entire drive for exchange of information started much before the BEPS project got initiated, now I think it's going to receive far greater degree of credibility because it's no longer exchange of information. Now they're talking about automatic exchange, spontaneous exchange, so on and so forth. So all of these new terms, I think, is going to impact multinationals, how they structure operations. It's going to impact tax administration. How do they really assess multinational corporations or large corporations with cross-border operations? And certainly it's going to impact the taxpayer, the tax advisors and the tax lawyers, because they are going to be very active in advising clients on how do these transformational changes impact businesses of clients.
So Ajay, if I see the two basic themes of BEPS, one is transparency and the other is substance over form. So isn't substance over form a theme which has already been a driving force in the Indian tax courts? Do you think that something will substantially change?
You see, as Mukesh rightly mentioned, there are far-reaching changes that are sought to be brought through this BEPS report. And although you rightly put it that substance over form has guided our courts, you tend to remove the cloak of the transaction if you really feel that it is, driven, it is collusive, it is sham, and driven by considerations of tax avoidance. Now, once this is documented, and especially Mukesh is referring to the treaty abuse provisions when he deals with substance over form. So, countries like Mauritius, Singapore, where we have preferential tax treatment with respect to certain classes of income. Now, unless you are able to establish that the entity in Mauritius or Singapore has substance and it is not just a conduit to root investment, the courts will have to go by the doctrine of substance over form. They will have to say that the treaty benefit is not available in a certain case where it is just a shell of the shelf company.
Okay.
Yeah.
So looking at the law, how Indian law has developed, we had the GAR introduction of GAR, General Anti-Avoidance Regulations, which has been pushed back by India Inc.
Right.
Do you think this is on the same lines? Would GAR sort of become preeminent in deciding everything?
I would think that GAR is part of your specific domestic legislation,
Right.
and this has overreaching or overarching influence between countries themselves. Countries
Right.
are cooperating on the BEPS project, so
Right.
this will impact your treaties as well. While through GAR you cannot unilaterally overwrite, treaties between two sovereign nations.
Okay.
But once this multilateral arrangement between countries is actually a reality, you will
Right.
have substance over form taking over even qua treaties.
Even
Yeah,
quad treaty.
even quad treaties.
So where does it put, as tax practitioners, I ask you, where does it put the whole gamut of tax planning? Does that become a irrelevant, extinct word, or is there still some, use or utility of that word? Mukesh, I'll ask you first.
Well, I think I won't say the word tax planning is carries now a stink in the BEPS era, but I would certainly feel that as an advisor, um, tax planning has to be now contextual. Let me give you an example of that. When we all started in the tax profession, the tax professionals and tax advisors did not have as much importance as we have today. And that's largely because tax as an agenda now has traveled beyond the CFO. It has traveled into the boardrooms. It is an important topic of governance in the boardrooms. So I think when you use the word tax planning, you have to give a context to it and say that, does this tax planning carry governance? Because if the answer to that is yes, then certainly tax planning becomes a very legitimate tool. This is more at a philosophical level. I think at a practical level, we have to sit down and interpret the law. So just to pick up the cue from what Ajay mentioned earlier, what will happen to GAR in a post-BEPS era? BEPS doesn't prohibit the G20 from having domestic legislation.
Right.
BEPS merely says that make sure that your domestic legislations are aligned as far as possible. For example, there have been unilateral action by some nations like Ireland, which is there in the questionnaire, UK on the profit repatriation tax, and the G20 feels that some of these unilateral actions will act as a stumbling block for seamless implementation of BEPS. Coming back to the GAR question, I think domestic laws of many countries will have GAR, but you will now also see after BEPS an inbuilt GAR provision in the treaties.
Right.
And I would certainly agree that the importance of treaty does not go anywhere. So you may very well have a conflict situation of a domestic GAR versus an inbuilt GAR in the treaty. And clearly, in my view, treaties will override the domestic GAR. So I think those are some of the kind of situations you will encounter. I think it's been a blessing in disguise for India that though the GAR was deferred for a totally different reason altogether, but I think with April 17 as the terminal date now for implementation of GAR, it seems more or less that the dates are aligned to implementation of the first set of proposals by the G20 on the BEPS project.
So, if I may add on the tax planning, I think tax planning carries with it a sense of responsibility. I wouldn't say that people in the past also, suggested or advocated aggressive tax planning sans substance. Now, what is important is today, if you choose a country in which you need to set up a base, you have to make sure that while that country is a low tax jurisdiction, you have the necessary flesh to the structure that you create. There is substance to that structure. So certainly advisors will have a role, but advisors will caution the client that look, if there is a choice of jurisdiction, you must make sure that company or the entity that you set up there is carrying on substantial operations in that country. It must have staff, it must have an office, it must carry on substantial activity which adds value in that country. So from that point of view, tax planning is not totally eliminated,
Right.
but it will take a different contour.
So, as you mentioned, shortly after the BEPS final report, Ireland reduced its tax rate further to 6.5%, as if trying to show defiance to the whole thing. And a normal multinational corporate, which owes its first allegiance to its shareholders, do you think there would still be countries which would be competing for investments and therefore diluting the whole cohesiveness that is required for BEPS to work?
I think the caution that is sounded, and as Mukesh put it, is for a uniform policy in the local legislation, in the domestic legislation. If your domestic legislation is at variance with what is advocated in the BEPS report, it will certainly be adding to some hurdles in implementation of this seamlessly across borders. So yes, countries will have their individual agenda. Like for instance, you have states with their individual agenda, seeking to attract investment to their jurisdiction. Yes, it will on the practical side be a challenge. But the countries must, in order that BEPS becomes a reality and becomes successful, must ensure that by and large their domestic policies are not at crossroads with what is advocated in the BEPS approach.
Absolutely. So Mukesh, a question for you, since you deal with a lot of transfer pricing related work. This whole thing on country by country documentation and creation of a master file, do you think that will require companies to relook at the whole function analysis that they have been doing since ages and go deeper, especially where intangibles are concerned?
Well, two things at a very general level before I get into the point of intangibles. What does country by country reporting really mean? It really means that you open up the entire supply chain for the tax administration. So the tax administration can make an assessment, you know, where are the headquarters, where are the regional headquarters, where is the value, where are the intellectual property, so on and so forth. Now, it's going to transform really, in my view, the manner in which multinationals have to go about doing the documentation. So I think first is a additional compliance requirement, at least in the initial years, that the multinationals will face. The second impact of country by country reporting is that it gives access to the tax administration for documentation beyond their national boundaries.
Right.
What happens, say, for example, today in the context of India, you look at an Indian company, say that's a tested company, and it's foreign associated enterprise. You have visibility for the functions, assets, risk of the Indian company, and you may at best look at the risk of its foreign enterprise because that's how you gauge the arm's length price of the transaction between two. Now, under the country by country reporting, the administrations get a view of transactions beyond the immediate foreign enterprise that's doing the transaction. That's one part of it. To your point on intangibles, I personally feel that the entire debate on intangibles, which as it is was not settled, is going to get even more muddied in the new environment. Because if you look at this whole debate on patent boxes, why is your intellectual property lying in a low tax jurisdiction? Is that an avenue for you to transfer the income? I think all of that debate is going to come up again. I have a slightly different view on the negative media publicity, and it's not a biased view. It's not because I'm an advisor that I have this view. So much has been written in the media about XYZ organization paying 3% tax, so on and so forth, parliamentary inquiries in various countries. Let's look at the other side of the coin. Why did the multinationals structure the manner in which they structure? All of these multinationals have good governance, good board, they are all responsible citizens. They did it because domestic laws of certain countries allowed them. And those avenues for planning, to your term that you used earlier, were available. Now, if this political class globally believes that certain countries are robbed of their fair share of revenues and they are going to refine the international norms, so be it. But let's not label these multinationals as someone lacking governance. Because I can tell you that if I'm a CFO of a large multinational organization, I'm going to go and tell my tax head, you know one thing, I'm going to look at the effective tax rate because the shareholders' interests are important for me. I have to deliver returns to them. I have to demonstrate to the street that I am the best performing company, which means that I'm going to use all legitimate ways and means to be able to save tax. So I think this debate has been one-sided in my view, and media has, kind of splashed negativity, activism across various parts of the world. All of these are important. I think perhaps BEPS is a solution to that. But to your point on intangibles coming back, I think that the debate is far more settled. And I just want to end by giving one illustration. In one of the action points, it's been mentioned that the entire debate on hard to value intangibles is open. What is hard to value intangibles? The two largest beverages companies of the world who have concentrate and they have 95% market share of the world. Is the formula for those uh, concentrates hard to value intangibles? Perhaps yes, but I can extend that argument to anything else.
Yeah, sure.
So I think we've got to a stage where the BEPS project and some of the terms that have been used in the BEPS have to be taken forward now, and we need to give some meaningful definition to all those aspects. Otherwise, I can tell you that this whole thing is going to be chaotic for multinationals and for the administration as well, and for the courts to be able to handle these disputes.
So that leads me to the
I just want to
question.
add 2 points, if you permit me.
Mhm.
One, if you look at the Vodafone judgment,
Yeah.
it legitimized holding company structures
Right.
because countries approved such kind of structures. Now, today you suddenly feel that these structures have become illegitimate because you are not paying tax in X jurisdiction and you eventually are subject to a low effective tax rate even in your source country or in your residence country. So, what was earlier approved and legitimate is kind of frowned upon in this new kind of arrangement.
The moral rate of tax.
Right, the moral rate of tax, right? So that's one aspect. The second on this country by country reporting, I have a question to both of you. Is in this you will have the transfer pricing at the end of the recipient of income and at the end of the payer of the income. So effectively, will it amount to a bilateral API between the two tax administrations of the two countries? Means they must then come to a conclusion, yes, that this country must get this share of the revenue, this country must take this share of the revenue. But it can't lead to a situation where there is double taxation.
Sure.
I don't know if we can avoid that in this BEPS situation.
Well, for large multinationals, even the most simplest of multinationals, their supply chains are structured in such a manner you can never have a bilateral. You'll have a trilateral, quadrilateral,
Right.
all kinds of situations.
Right.
So what's likely to happen is that if a dispute arises as to what is their fair share of revenues, you're not talking about two countries, you're talking about multiple countries.
Correct.
I don't know how it is going to be settled, though I must confess that there is a mechanism, at least theoretically provided in the action point. So if you look at action point 14, action point 14 is nothing but a direction, and maybe direction is not the right word to use, but whereas BEPS says that we will not have a situation of stateless income, BEPS also says in action point 14 that we will avoid a situation of economic double taxation, and that's where they have to provide a framework to resolve. But my question is that we already have a framework in the treaty, don't we?
Yeah.
Despite that, we have economic double taxation. So the biggest question that businesses have is that if we could not resolve through the mutual agreement procedure of the treaty, and it's not just India, I think it's the phenomena of rising unresolved MATs is across the world. How is action point 14 now going to give a solution? Because I can tell you that disputes on economic double taxation in the post-BEPS era are far more accentuated than in the current extant law.
Yeah.
And hence, action point 14 has to be far more than a stated intent, which is the way I read action point 14. So I think it's going to be a real challenge. I think people are going to wait and anxiously look at, businesses are going to wait and anxiously look at how this is going to be dealt.
I think just to add to the hard to value intangibles, I think it's a matter of perception. You can't have a formula of determining the value of an intangible. It may differ from person to person.
But is it going to make the tax authorities trigger happy and seeing value in everything, especially when you have R&D centers and
Sure.
KPOs in India, Mukesh? A lot of companies have R&D centers here which are treated as cost plus or a contract R&D. I think one of the things BEPS says is that ownership of intangible is not as important as the evolution and development and maintenance. Do you think that is going to give a machine gun in the hands of the tax authorities to rip everything apart? I ask both of you one by one.
I think this is a very philosophical argument. Philosophical because India as a country is still a net recipient of FDI. India has created an ecosystem for R&D centers or captive centers because it's a major source of economic activity. So I think countries like India and all the emerging markets have to balance out and not push their luck insofar as BEPS is concerned. Otherwise, it's going to drive away investments from the country. To your point, uh, how will the tax authorities look at an R&D center purely from a characterization viewpoint? I think we've taken some positive steps, at least to make sure that we don't confuse every R&D center as developing, intellectual property in India, because otherwise the tax authorities would classify every R&D center as a full risk entrepreneur-driven R&D center. So I think those steps that we have taken ahead of the BEPS exercise in my view, are positive steps. But I think they need to be implemented in all earnest. People come to India for R&D activities or captive outsourcing activity because they have the arbitrage, the cost arbitrage. And I think it is incumbent then upon India to make sure that they stick to the spirit and the business agreement of it. Uh, Today, if you go and ask any multinational, are they doing full R&D activities in India, as in intellectual property resides in India? Then the answer clearly would be no. The fact is that all of these R&D has been funded by overseas enterprises. So the first primary condition for this R&D to be classified as contract R&D is met. But I think still we have left the rules a little bit nebulous by saying that it is not what is written in the agreement, but it is the conduct of the party. It is a substance that we need to look into it. So I think India, countries like India, which will continue to be, in my view, net importers of technology and investments, have to be very, very walking balance it, because otherwise you may want to implement this in full spirit, but you're going to drive away investments, because that's not what the stated objective of the highest political class is there in this country.
I think what Mukesh says, ease of doing business, will have to be balanced with a very aggressive tax position taken by the tax administration.
So that has.
I think that'll be the key.
Has to be set from the top, because
right.
the assessing officer doesn't care if FDI stops.
And there is a lot of subjectivity around valuing intangibles. So you have to see that the a dispute that we currently have on AMP expenses is an example in point. So I don't think we can repeat those kind of postures in the near future if you want to really attract business to this country.
So final question to you, Ajay. How does BEPS become operational? Is there something that needs to be brought into the statute? The report talks about a multilateral agreement to tie everything in. Again, a sort of a philosophical question, but what do you see the road forward?
I think BEPS gives us an overall framework, and maybe there will be some changes in our domestic law. Like, for instance, they talk of a controlled foreign corporation. We might bring in those rules. I think sooner than later they will be part of our domestic legislation. You may have tweaking of some treaties on a bilateral agreement basis, and if the multilateral arrangement comes into existence, which will override the treaties that we've already signed, then that will be the way going forward. That will be the law so far as India is concerned. So I see that happening in the near future.
Okay. So let's all look forward to what happens. So I guess if you have a quick 2 words to tell your clients, will it be wait and watch or be ready?
I would say start getting ready. I would never tell my clients wait and watch, because if we discuss BEPS, say in 2011-12, perhaps I would have said wait and watch. I don't say that today. I would say get ready for transformational change.
So that's it, viewers. I hope you got Mukesh's cautionary statements, and we watch this space as closely as possible. So moving on to our next topic, which is again related to international tax, foreign tax credit, and although foreign tax credit has been an issue for lots of companies, especially exporters, surprisingly there is very little jurisprudence on that. And why do you think? Has it never been an object of dispute or lack of understanding?
I would say, a couple of factors. A, you had few instances of Indian companies going overseas and earning income overseas. B, there, at least in terms of perception, never was an issue that you could possibly claim more than what you paid, and on tax exempt income in India, you could claim the offset of the credit. This is a path, the Wipro judgment that you have in mind is probably a path-breaking initiative where the court seems to have taken a view which was not visualized by tax practitioners when they advocated that you cannot claim credit for against income which is not chargeable to tax in India.
So, if you could just quickly give the synopsis of that judgment.
In the Wipro case, you see, they earned income in the US and in India, which was attributable to their STB units in India, which was not taxable in India by virtue of the exemption under Section 10A. Now, taxes were withheld in the overseas jurisdiction for which credit was claimed against the Indian tax payable on income other than the income from these software units, software export units. Now, the court held, to me very surprisingly, that notwithstanding that tax was not paid on that exempt income, but since this income was chargeable to tax in India, but by virtue of the exemption or deduction in 10A, tax was not eventually payable on such income, you could still claim credit of the tax paid overseas against the tax payable on the Indian income other than this income. Now, if we look at the wording of Article 25 of the India-US Treaty, which has been the subject of interpretation in this Wipro judgment, I think it says that the credit is limited to the tax that you paid on the Indian income. It must be income which is doubly taxed. That means income that suffers tax in the source country as also in the country of residence, in this case India. And secondly, the tax credit cannot exceed the tax attributable to that doubly taxed income.
That's right.
So that, to me, that was always the view. So that is why when you said there are no disputes, I think I never canvassed that you could claim credit of such tax paid against income which is exempt from tax in India.
So, when these kind of unexpected bounties come from the high courts, what would be your advice to a client? Can they use this as a precedence, or what would you say after reading this order?
I think it's a question of what opinion someone expresses. Much to the displeasure of multinationals, I echo Ajay's sentiments that it seems High Court has taken a rather liberal view, and I would, sit and wonder whether this would not come up for debate in the highest court of law. Clearly, I mean, this decision is binding on all taxpayers subject to the jurisdiction of Karnataka state, so there is no harm in taking a position that this is a decision that is in our favor. But I would be a little skeptical taking this position outside Karnataka state, because I clearly feel that we still need to see the final word. And I hope I'm wrong. And I hope that my guess that this is a liberal interpretation is proven to be incorrect. Because it seems that it goes against the fundamental principle.
The general understanding.
Right.
No, with respect, I think the way the court has interpreted possibly is not correct. You've interpreted the language of the Indian statute and sought to import that into interpretation of the treaty. I think treaty interpretation is completely different than a complete literal interpretation of the words of a statute.
Right.
So and as Mukesh said, this judgment will be tested in the highest court of the land. And clients have also been asking me of whether they should be making a claim. But while it is suggested that you make a claim basis this judgment, it is also cautioned that you must bear in the back of your mind that eventually this may not succeed.
In fact, if one goes with by this judgment, you can make a claim at the time of assessment itself. You don't have to claim it in the return. The next point, tax credit for state taxes paid in the US. I was brought up to understand that state taxes of the US can never be claimed as foreign tax credit, and it was a revelation to me. It all made sense the way the court has explained to me. But so, what is your view? Is it again something which is a more liberal?
I would think that we will have to be governed by the strict terms of the treaty. So you have to really look at the terms of the treaty to determine whether you will be able to get this credit. And in my view, the way the treaty reads, one's income is not subjected to tax in India. It is not doubly taxed income. And tax attributable to that income cannot be claimed offset against other income.
And it has to be federal tax, or even state tax can be imported into the whole definition.
I have not read the judgment, neither have I looked at what kinds of taxes are covered in the definitional aspect of the treaty. But my general understanding is that it should be only federal taxes.
Federal taxes. Okay. So a nice, good news. One rarely gets it from the court these days, but do proceed with caution. That's what Mukesh and Ajay are quite agreeable on. So moving on to our next topic, which actually coincidentally was on the front page of Economic Times, MAT on foreign companies.
Right.
After the Shah Commission report and the government's press release, I thought the dust had settled on that. Has the dust actually settled?
No, this only shows the revenue will never give up.
So just for our viewers, if you can elaborate.
See, basically, the Shah committee was constituted in order to suggest whether the provisions of MAT should be applicable to FIIs.
Right.
And I was amongst several other people had made a presentation before the Shah Commission. I must say they gave us a very patient hearing, and the recommendations are very well compiled. So two things clearly came out, that the way Section 115J or JA or JB are worded or structured, and looking at the intent and the spirit of behind introducing those provisions, the intent was never to tax FIIs. In fact, we pitched saying that foreign companies per se should not be subjected to the MAT regime. The Shah committee said that our mandate is only qua applicability of MAT provisions to FIIs. In fairness to them, they restricted themselves to making that recommendation, but they put other points across, saying that there is equally a strong view that MAT provision should not be applicable to foreign companies.
Right.
Which the finance minister announced that appropriate legislation will be brought about to point out that MAT is not applicable at all to foreign companies.
Right.
So that's the background of the Shah committee report, and I think it was a very welcome step. It was a very welcome step, in setting up the committee. The committee submitted a report in a time-bound manner, took views of all sides, and ultimately the government accepted the recommendation, which is the more critical part.
Right. So I think where it left, as you said, the tax authorities, they said as long as the FIIs don't have a place of business or a permanent establishment, and that seems to have been the next venue of attention. So you deal with a lot of FIIs. Do you think this is going to create further trouble? Every time FIIs sneeze, our stock exchanges catch a cold. Are we again, should I sell my stocks quickly?
So I think that in my view, this controversy has arisen because of incorrect interpretation of the law. That said, this whole debate on MAT will apply when there is a permanent establishment for treaty countries, or MAT will apply when there is a place of business in India for non-treaty countries. I think these words have seeped in because of the AR rulings. So if you read the AR ruling in Castleton's case, or if you read the AR ruling in earlier cases, this place of business has been used over there. In my view, that led the Shah-appointed panel to really dwell into these issues. Is place of business a precondition? And I won't put a blame for that on the Shah Commission, because they have given a report based on the terms of reference that were given to me, and the terms of reference clearly said, will it make a difference from a MAT levy standpoint whether they have or do not have a place of business in India? And also bear in mind that before the Shah panel recommendations were finalized, the two CBDT circulars that were issued, one in the context of treaty, were making again reference to the place of business in India. I think this whole debate can be put to rest only with an amendment in the law, which is what the Shah panel has also recommended. And I think that this debate will only end after there's an amendment in the law, and until that point in time, this will remain a contentious issue. But to me, as someone mentioned to me, you don't need to be a third year law student to interpret the law. The entire history of MAT, the purpose of levying it on zero tax companies declaring dividends in India, so on and so forth, is clearly suggestive of the fact that there is no case for levy of MAT even to a foreign company, leave alone an FII that does not have a place of business in India. But yes, based on how the panel has concluded, to me it seems that they have left it open. Having said that, I think it's also important to read the 3 pages of observation that were made by the Supreme Court pursuant to the government issuing a press release on accepting the Shah Committee recommendation, because there the Supreme Court, I think, went ahead and recorded the statement of the law officer, the Attorney General, saying that the government will endeavor to amend the law. So I think the ball really, in my view, right now is in government's court. I would like to believe that field officers, should not, get a little overambitious, despite all that has happened, all the damage it has caused, all the anxiety it has caused on this whole levy of MAT issue, and wait till the law is amended. I think after the law is amended, there should be no doubt in anyone's mind about the levy of MAT.
I think just to add to what Mukesh, I just put this in perspective. You see, one of the arguments put forth before the Shah Commission was that MAT, the starting point for levy of MAT is maintenance of accounts in India.
Yeah.
And companies, let us say FIIs or even foreign companies, which have no place of business in India, which have no fixed place from where business is carried on, are not required to maintain accounts in India. Mm-hmm. So under the relevant provisions of the Companies Act, if I remember correctly, section 591 of the 56 Act, it required you to submit accounts to the registrar of companies only when you had a place of business in India. Yeah. So what was advocated in the Shah recommendations was that since the FIIs don't have a place of business in India, they are not required to maintain accounts in India. So clearly, MAT provisions are not applicable. Right. The revenue authorities seem to have picked up a cue from there to say that proves that you don't have a place of business in India, you are not liable to maintain accounts in India, and consequently, there should be no levy of MAT.
So the onus has been shifted on to the taxpayers.
Right.
So generally, what has been your advice to companies who may be in this kind of a predicament? Do they wait for the law to change? Should the government change the law, immediately? What would be your?
You see, this is just one of the arguments why MAT is not applicable to FIIs or to foreign companies. Now, when you maintain accounts in India, it's not those accounts on which you seek to subject that particular entity to MAT. You are looking at a profit and loss account, which is placed before the shareholders.
That's right.
Your policies in those profit and loss account or the balance sheet should be same as in the accounts placed before the shareholders at the annual general meeting. Right. It must maintain the same particular financial year, same as Indian tax purposes, 1st April to 31st March. All those requirements are not complied.
That's right.
So these are additional points to say why MAT is even otherwise not applicable either to FIIs or to foreign companies. The revenue has just picked up one point to say prove that you have no place of business in India.
So the whole thing does not just turn on the place
of business. Right. Precisely.
So
I think it will give some handle to tax practitioners if such cases come up, which will be completely unproductive.
So a good fee earning probably opportunity for tax practitioners. Not that one would like to chase or waste time.
Right, absolutely.
So moving on, the other thing which keeps tax practitioners busy is taxation on software. Taxation on software, and I remember reading the IFA judgment which you had argued, and I thought that this matter is sort of done and
put to rest.
But it keeps cropping up,
right.
And do you think this is another area where the government should come up with some guidelines? What is your whole situation? Because everyone, moving to a digital economy, import of software is every company of worth anything is importing something.
Right.
Where do you see this whole jurisprudence moving?
No, if we step back, you see clearly the Karnataka High Court took one point of view, saying that even off-the-shelf software payments are in the nature of royalty,
Right.
which are taxable in India, and consequently the remitter needs to withhold tax. The second, in fact, all other high courts took a view to the contrary, saying that software which is in the nature of a copyrighted article cannot be treated as royalty and subjected to tax in India. The matter is presently pending in the Supreme Court. But the government, instead of seeking to clarify the position, muddied the waters further by making that retrospective amendment. Now, in the explanation that have been added to Section 916, all these payments today under the domestic law are taxable as royalty, and there is a dispute going on whether you can read that unilateral amendment in our domestic legislation even as part of definition of the treaty. And to compound matters further, for non-deduction of tax at source, the retrospective amendment is being read as if there was an obligation to withhold tax at that point of time. So the matters are all in court. I think the government is doing nothing to clarify this position. They are letting the courts take their own view and law take its own course.
So Mukesh, I remember you were part of that high-powered committee on e-commerce taxation way back in '99, where the government, totally in divergence to the tag OECD view, held every kind of payment for software as taxable as royalty. From '99 to 2016, nothing has changed.
Well, I think this is a good example of how when decisions are not taken on time, where it lands. Like Ajay said, that everything is now lying in the Supreme Court, and we are sitting in 2015 now. In 1999, when the government set up that committee, it was more in relation to or rather, it was more a reaction to uh, you know, many countries that were experiencing the e-business boom before the dot-com crash, as to how do you deal with this vexed issue of e-commerce taxation. And at that point in time, the TAG report, which specifically dealt with the characterization of income in the context of software sale, which clearly laid out the principles. The first principle of TAG was that mode of delivery of a product will not alter the characterization of income. And as a matter of fact, we captured this in the expert committee report on the first page in the preamble itself by saying that, does it make a difference whether you buy a music CD or you download music? It shouldn't. That is what was a stated objective. But I think they really went into interpretation of 916 even before the amendment and said, well, under 916, some of these payments will be held to be taxable. Many instances were given even after the committee report was submitted. We had cases where countries like Singapore, administered a law called shrink wrap software will be exempted because the shrink wrap software is nothing but a product. In fact, the government should have picked up, cues from the decision of Tata Consultancy Services,
Right,
where they said software is goods and not services. But I think that the whole debate on or controversy on characterization of software income is nothing but an outcome of the government, consecutive governments ignoring not just the recommendations of the expert committee, but also all the jurisprudence that came. And I think the final nail in the coffin, as Ajay rightly pointed out, was the retrospective amendment. But even after the retrospective amendment, interestingly, Ajay, as you know, the Delhi High Court in the case of Nokia has given a verdict that you need to look at the definition under the treaty and not under the domestic law. But I think that in our country, till the time the controversy doesn't become of a particular magnitude, we don't tend to address it. Probably this controversy has not. But I can tell you that there are many taxpayers who have not double whammy but triple whammy. Let me explain it to you. This is an Indian company having purchased a software from the foreign company. So you first assess the foreign company that this is royalty. Then you assess the Indian company for failure to deduct tax. Then you deny the deduction to the Indian company under 40 because you have not deducted tax. So now we have not double, but 3 proceedings
Correct.
simultaneously. You're not talking about triple taxation, not double taxation.
And if the foreign company not paid tax, you have section 201.
201. So I think that this has been extremely carelessly handled situation. The government took a bold view by reducing the withholding tax from 25 to 10%. I think it should have taken a bold view in actually intervening in this matter and putting the controversy to rest. But it seems like this whole thing is now going to go to the final court of law.
I think while Mukesh referred to the favorable Nokia judgment from the Delhi High Court, there is the Verizon judgment from the Madras High Court, which takes a contrary view that the unilateral amendment in our domestic legislation has to be read into the treaty as well.
Yeah.
So the matter is still again in the Supreme Court, and it'll be some years before the dust settles down.
So even if the Supreme Court is the Supreme Court also going to decide on whether the treaty definition should be taken?
Yes, it will. Certainly. So what's going to happen is that there are a batch of appeals before the Supreme Court, and it's going to decide a batch of appeals, but the facts of each taxpayer are very different.
So it's going to take a long time.
Exactly. And let me give you 2 diagonally different facts. There are cases where I just import the shrink wrap software. Simple. There are cases where I am a reseller. So I import the software and I resell it. And there are umpteen number of cases in the middle which are different facts altogether. So I really have no idea how the Supreme Court is going to deal with differing facts, because the high courts are blindly and tribunals are blindly following these decisions. And I think that there has to be, I think there has to be a policy intervention on this matter. I don't see how the Supreme Court will be able to deal with complex facts of all these cases, particularly if it decides to take up all of this as a batch of cases.
Going by purely how the government works, once the matter lands up in court, it is seldom that the government will come out with a policy decision. At least I don't think that is on the anvil in the near future.
So all this talk about simplifying things, cutting legal disputes. Do you think in international tax, especially Section 195 software import, is a major area of tax policy reform?
It's a major area of tax policy reform. I think what is also important is that it just reduces the enthusiasm of the investor. To invest in India, even if the dispute is a past dispute. So let's say, for instance, after the change in law from April 1, 2015, people will say, okay, let's pay 10% tax and forget about it. That's the cost of doing business. But 25% gross tax, which was the maximum, is a big hole.
Yeah.
And then the court cases, and then the frustration, timing issue. I think it certainly impacts, in my view, the ease of doing business in India. So I have no reason to doubt the intention of this government at the highest level from a stability point of view. But I think the real reality is what we face when we go every day to face the assessing officers and face the first appellate level and the tribunals. So I think that's where the difficulty lies.
Curiously, in this case that I have referred to here, the tribunal didn't even go into the question of whether it is royalty or not. No. They just said that this is a reimbursement. There is no marker, so this is not subject to deduction of tax at source. Actually, a surprising decision. So I guess the synopsis is that software will continue to be a area of litigation for quite some time as we go forward. So moving quickly on. The other development on transfer pricing last week, which was coming out with the rules. The Rule 10CA was inserted, allowing a range concept to be introduced and use of multi-year data. So, Mukesh, I would seek your views on, how do you see this development?
I think it's an excellent development. It's very positive, but long overdue. I think if you look at several hundreds of maps between India and US which remain unresolved, it's primarily for that reason. When the competent authorities of the 2 states sat down, the US competent authority took a view that internationally you use an interquartile range. And India said, well, our rules say we use a simple average mean, and that's where we got stuck. My simple view was that it is nowhere written in the income tax law. It's a rule. You can always amend a rule. We could have amended this rule 5 years back as well, because interquartile range is an OECD accepted, internationally accepted norm. So I think it's very good. The other heartening thing that I see in the amendment to the income tax rules is that they have actually given illustrations how it will apply. Because bear in mind, writing down the rules is one part of it, interpretation of those rules are another part of it. If we give illustrations by way of interpretation, I think it helps in ease. So I have not read the entire thing, but I saw some statistical analysis by way of illustrations that are given to be able to support these rules. So I think it's excellent move. I personally feel here is an opportunity for us to say these rules should apply retrospectively.
I think they've said transactions after April 14.
That's right.
Yeah,
but I don't see any reason why a tribunal should, having taken a view that multiple layer data is not allowed, should not allow these rules to be made applicable to settle the past disputes as well. Because in my view, these are, machinery provisions dealing with the procedural part of the law. They don't bring any fresh charge to income tax. And if there are any proceedings that are pending before any judicial forum, they should be allowed.
So I fully agree with you that by giving illustrations, in fact, when I wanted to understand the rules, I looked at the illustrations first and then read
It's fairly
the law.
detailed.
But coming from the illustration, I have a question for you, Ajay. Is in the illustrations there was a mention of that at the time of assessment, if the assessing officer, a new comparable has crept into the data set, or based on some new data, one comparable has to be rejected, a fresh data set will get created at that time. Do you think this is a fair aspect? Because as far as I understood, contemporaneous document meant the data which is available to the taxpayer at the time of filing the return, and subsequent developments should not be taken into consideration.
No, while you're right that your documentation is on the basis of contemporaneous data and evidence available at that point of time, so therefore that may be relevant from the standpoint of levy of penalty. Suppose you've not looked at a comparable whose data was not available at the time when you prepared the documentation.
Right.
For reasons of defending the penalty, this will be a good defense.
Right.
But for determining the ALP, I don't see any reason why this data, which is relevant, should be left out. And it equally applies from the side of the taxpayer also. In Aztec's case, you would be aware the special bench held that you are not bound by the comparables that you took when you prepared the documentation. You could introduce a new comparable provided data is available for the relevant period.
So it's a double-edged sword.
It equally applies from both sides. And so long as the revenue confronts you with the data, makes available all relevant information in respect of that comparable, I see no reason why that should be left out.
Do you agree with that view, Mukesh?
Yeah, entirely agree. I think, tax contemporaneous data means data available to the taxpayer at the time of doing the documentation. But if at the time of doing the assessments, the latest data is available, and let's assume that inclusion of that data results in a different arm's length price, then clearly the taxpayers cannot be charged penalty for that. But tax authorities may be well within their rights to be able to carry it. Though I personally feel I would go a little forward and take a liberal interpretation that if on the date of the documentation, the taxpayer is able to prove that his transaction is on an arm's length basis based on the data available on that day, the revenue should not question it. The fact that at a subsequent date, that data got available should not then lead us to doubt that the SSE had contrived to use the old data and the old data was used with an intention to shift profits, so on and so forth. Because at the end of the day, the way I look at the transfer pricing law, it's not a mechanical arithmetical exercise. It's an exercise where you have to go to the intent. Did this taxpayer intend to shift profits? And if the answer to that is no, and he's supporting it with contemporaneous documentation, there should be no case for any adjustment.
So you mentioned that globally there is a use of the interquartile range.
Yeah.
But what the authorities have done is limited 35 percentile and 65.
That's the Indianized version of
So it's like
interquartile
giving
range.
and taking something back.
Absolutely. We have to be innovative, right? So we are innovative here.
So you're happy that at least it's a start, and every year you will push it a little bit.
Yeah. It's a good start, no doubt about it. But I think we are a little bit creative and innovative over here. I think the world I had a conference call day before yesterday, and I was actually at pains to explain this to a US transfer pricing economist, because that economist was asking me the same question: why 65 and 35? Do you know of any country that has done it? I said, yes, I know. No, India has done it today. So I think it's a little bit innovative. But you know what will happen? If the 65-35 principle now comes in conflict with India's treaty partner, say for example US, then how do you resolve a dispute? So I think there is a price that we will pay for this innovation somewhere or the other, because I have no doubt in my mind that that variation that we have made in our interquartile range principle could lead to its own set of disputes. So let's say, for instance, if I come from a treaty country, can I take a view that my country says interquartile range has to be read in this manner, your country says, can that give a rise to a dispute? It could. So India would like to argue that the source country rules should apply.
So I think BEPS will have this added headache to resolve between countries.
Yeah. I can say that
inconsistent domestic legislation will definitely create headaches for BEPS implementation.
But well, to be fair, then India is not the only country with inconsistent legislation. If you look at Brazil, Brazil for transfer pricing purposes uses a straight benchmark. So if you're providing corporate advisory services, this is the benchmark. If you're providing R&D, this is the benchmark. So they actually, give way completely to the arm's length principle, which is a complete disregard. It goes against the grain of a transfer pricing law that you start assessing income based on economic value. So I think there are many countries.
So we are not up there, but we are not.
We are not up there. Yeah.
Okay.
Yeah, there are more countries than India that have bizarre international tax and transfer pricing laws.
Thank you. So I think that takes us to the last topic, and I don't know whether you would like to comment on it. I had kept it as a topic because the most recent transfer pricing judgment on Vodafone had come out in Mumbai High Court. It was read orally, but I think the written order is not yet available in the public domain. So I guess as professionals, would you still like to make any comment on it?
I think it'll be premature from my standpoint to comment actually on the content and the reasoning of the judgment.
Right.
But we know as a fact the decision in the matter.
That's right.
That assignment options that were passed on to the AE,
options,
that was held not to be an international transaction, which could be subjected to transfer pricing adjustment in India.
Right.
So I think that, and even when I read the tribunal judgment, I really couldn't figure out how that could result.
So on
in any
merits, you
advantage.
feel that's a correct.
That's a correct.
Yeah, I think it's speculative to say anything, but I think the debate, if I recall, has been this goes back to the days when the Indian income tax law did not have a specified domestic transaction within its realm. And at that point in time was whether a transaction between two resident companies be a deemed international transaction, because it fell into the deeming category.
Right.
I think it will depend on facts and circumstances of the case, and I have no doubt in my mind that if the High Court has given a verdict that in Vodafone's case, this transaction is not an international transaction, it would have gone into the facts of the transaction and then come to the conclusion. But nevertheless, it will be interesting to read the judgment, because this whole debate on what is a deemed international transaction is a big debate. So I'm sure that the High Court decision will lay down some important principles to put an end to all forms of controversies on the deemed international transaction.
So for me, I think this is something close to my heart. That if a transaction does not produce income, for instance, the options were assigned at nil value for no consideration, can you in that situation impute notional consideration? I strongly believe that transfer pricing is meant to allocate profits between different taxing jurisdictions in which the affiliates of the M&E group are located. It is not meant to bring to tax illusory, hypothetical, or artificial income, which is what the Delhi High Court has also said in Sony Ericsson and reiterated in Ram Green.
Right.
That transfer pricing can't produce income. It is seeking to allocate disclosed income of the group between different entities.
Right.
So I would wait to see the text of the judgment to see how this has been addressed.
So we'll keep this topic alive for
Yeah,
our next
sure.
webcast. So that brings us to the end of this discussion. I thank you again,
Thank you.
Ajay,
Thank you.
and thank you, Mukesh, for
Thank
this
you. It was
interesting
enjoyable.
webcast. And I thank you, viewers, for a patient listening. And if you have any queries or feedback to give us, do write to us and send in your comments. We will be doing this on a regular basis, and I look forward to having Mukesh and Ajay again in the very near future. Thank you very much, and
Thanks.
have a very nice day and a very nice weekend also.
Thank you, Amitabh.
Thank you.
Thank you.
Thank you.
Thank you.